All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is State versus Reppel, number 2024-1088.
Mr. Chief Justice, and may it please the court, Derek Monson on behalf of the state. This case asks whether two indisputably accurate and highly incriminating breath test results that the defendant consented to twice over must nonetheless be suppressed simply because the arresting officer transported the defendant to the county breath test facility in the neighboring city. The answer is no for two independent reasons. So one, transporting a defendant to the county facility that services his jurisdiction is necessarily part of the officer's authority to enforce the law in his jurisdiction. But regardless, this is not the sort of issue to which the exclusionary rule would apply anyways, so I'm not even sure a motion to suppress is a proper vehicle to consider that question. I'm happy to talk about either issue, which we think provide an independent basis for quashing the decision below, but otherwise I will start with the merits. So municipal police officers are vested with very broad authority.
Can you explain what rule you're proposing? Because you don't seem to truly defend the 5th DCA's continuing investigation sort of framework. I think, what I pulled out from the brief was an incidental use of a limited amount of authority. What sort of rule are you using as an exception? Where does it come from? Can you explain that a little better?
Yes, so I think, we're not urging for an exception. So I think, we agree you have to look at the statute because, a police department's authority is created, the police department is created by statute. Their authority both within and outside their jurisdiction is governed by statute. So we have the statute here going all the way back to the City of Maitland's original charter and then also the Home Rule statute that gives them the authority to basically take all necessary steps to enforce the law in their jurisdiction. Now, I don't think we're running from the 5th DCA's rule here. I think it's entirely possible.
Well, do you agree with that the kind of like continued investigation framework is probably, as the court in Reppel noted out, probably kind of just a loose term that got used and reused throughout Florida jurisprudence without kind of a rooting case or principle?
I do think that that's correct. So we wouldn't call this like I said, we wouldn't call this any sort of exception. We wouldn't call this a continuing investigation exception. I do think we would argue that an officer investigating a crime that occurred in their jurisdiction is an incidental exercise of their authority to enforce the law in their jurisdiction. Now we don't think the court necessarily needs to reach that broader question of can a police officer literally do anything in another jurisdiction as long as they're investigating a crime that occurred in their jurisdiction.
What would be the rule that we would make then? So are you asking us to just say for the purpose of this statute, for the purpose of implied consent, and a DUI, they can cross jurisdictional bounds, but we won't talk about anything else?
Yes, so I think, all the court needs to say to resolve this case is that the implied consent statute makes clear arresting officers have the authority to request a breath test, and that is an incident to a DUI arrest, and that necessarily is encompassed in the officer's authority to enforce DUI.
So in the state's mind, it's similar to something as simple as booking
Correct.
a person.
Yes, we would say requesting a breath test is simply part of the booking procedure when there's a DUI arrest. In fact,
except that it isn't a misdemeanor to refuse a booking procedure, right? What importance should we ascribe to the fact that declining to engage in the breathalyzer exam would constitute a separate offense committed outside the territorial boundaries of Maitland?
Yeah, so I don't know that that necessarily changes the officer's authority to request the test in the first place.
But I guess my question is, what's the state's position? I think I have a position, but what is the state's position on the effect of that fact pattern on the officer's authority? Like, for example, if, let's say, Mr. Reppel declines the breath test, do I now need a different officer to charge him with that misdemeanor, or can the Maitland police officer charge him with that misdemeanor? Or seek charges, I should say. The state attorney is going to charge him.
Sure. Admittedly, so I haven't thought about that exact angle, but I do. I mean, speaking here on the fly, I think it's probably correct. The police officer, I mean, that would be a crime that occurred in another jurisdiction at that point. So that you would, it would have to be a police officer in that jurisdiction, although he's already in custody. He's already in this police officer's custody.
Yeah, I mean, I think this sort of, authority by spoonful is kind of weird. It would seem to me that the line is, if he's committed, I would guess that the state's position would be something like, once the arrest is complete, once the officer had probable cause to arrest this person and restrain his movement, then this analysis about the roving authority of a constable or whatever is sort of, now it's out the window, because I've restrained this person's movement. He's going where I tell him, and if he commits another crime, for example, if he spits at me through the separation in the car, right, he's committed battery on a law enforcement officer, I think the state would say. And I don't know that he then has to figure out where the spit hit him and call the police department there. I've restrained his movement. So why isn't the rule, to get back to Justice Sasso's question, why isn't the rule that the state is propounding actually much broader than what you're saying, which is like, hey, if we've arrested the guy, I'm now investigating further crimes?
Yes, that's correct, Your Honor, and I think we do say that in our brief. So once he's in the police officer's lawful custody, the police officer has arrested him for an offense that occurred in Maitland. He does not have to release him at the town line. He can continue, he can get evidence from the suspect while he's in his lawful custody. He can continue to exercise police authority over him while he's in his lawful custody until he releases him to the Orange County Sheriff's Office at the Orange County Jail.
So it's even accepting your rule, which I'm still not quite sure where that's coming from, where we can say that like an incidental exercise of power that's, I think you've recognized as a statutory grant of power, that as long as like we incidentally use that, it's fine, even though it's a creature statute. But accepting the rule, why would it not be limited by something that's like a natural consequence? Whereas, so somebody's in custody, they spit, if that's the example. I think there's that second line of cases on citizen's arrest, which has addressed some of the ways you can arrest outside of jurisdiction. But booking would be a kind of a natural consequence. But then we have the breath test, which is kind of, it's separate. It's not necessary to prove a case. It's not necessary to prove a DUI. It's now the separate act of obtaining evidence. Even within your rule, how is that incidental?
So I think our rule is that anything that the officer is doing in furtherance of some legitimate law enforcement activity in their jurisdiction would be encompassed. So, for example, how
do we run that up against our stated rule that the officer can't collect evidence outside of its jurisdiction?
Well, I think. So I don't know that you've ever said an officer can't collect evidence outside the jurisdiction when the officer is investigating a crime that occurred in their jurisdiction. And so what I think the rule is that a police officer, so they have the full police power of the state to enforce law and order in their city. Obviously, that means they can't go to another city to enforce law and order in that city. The Maitland officer can't go to Orlando, pull people over for DUI, and arrest people there. For DUIs committed there, he can't run to try to take over a murder investigation in Miami. But that is obviously not the situation we have here when an officer is investigating a crime that occurred in their jurisdiction. I mean, here, it's going to usually be the case that evidence of the crime is going to be all over, potentially all over the state. Crimes are not limited all the evidence is not necessarily limited to that specific city, and I think it would hamstring officers in their ability to enforce the law in their jurisdiction if they just simply had to rely on the cooperation of.
Good policy argument. My concern with this is that, you know, bad facts make bad law. You've presented a very complicated argument that I'm not sure what the boundaries of it are, the root of our authority to create that rule is, whereas the legislature has created a very simple way for the officer to get this, which is through the mutual aid agreement, which likely maybe existed in this case. It just wasn't entered into evidence. So not overlooking that aspect of reality, why from a policy perspective we would not be content with the legislature's chosen policy to kind of effectuate these agreements and the necessity for these officers to be able to go to the next city to get a breath test instead of creating this kind of common law rule in a statutory context here.
Yeah, so I mean, we certainly think a mutual aid agreement could be used to cover this sort of scenario, although I don't know that I mean, you read the mutual aid statute.
Yeah, help me understand that, because who's aiding who? Because this is all about enforcing the law in Maitland in pursuant to this crime that's there. So I don't understand who's aiding who. Under the mutual aid, typically, it means an officer can go from one jurisdiction into another to enforce the law in that other jurisdiction, right?
Yes, that's correct.
And that doesn't really fit this circumstance.
Which is what I was about to say, Your Honor.
I thought so.
So you look at the mutual aid statute, and it really is the scenario that it's contemplating is a jurisdiction, one police department basically requesting assistance from another police department. So you might have, you know, a particularly large event, maybe the President of the United States is speaking in Orlando or something, and they want to ask the Maitland Police Department for assistance. They can have this written agreement that allows them to request that assistance. They come, the Maitland Police Department can then exercise authority in Orlando pursuant to that agreement. Obviously, that's not what we have here. This Maitland officer was not assisting the Orlando Police Department in any sort of law enforcement function. He was enforcing the law in Maitland, and this was simply the final step of a DUI arrest that occurred in Maitland. But even, Your Honor, go ahead.
Oh, I just swing around.
Can we just back up a second though, because it seems like part of and I want to make sure that I understand whether you're going along with this premise. It seems like a lot of the questions have been going to like looking for authority in a statute, et cetera. Though I thought the logic of the Constitution post 1968 is that cities have these municipal powers that are granted in the Constitution. It's part of, you know, inherent home rule. It sort of was a sea change. Pre-1968, the legislature had to affirmatively grant cities whatever authority they have. Now it's constitutionally derived. And statutes are the source of limits on cities' authority. Then it seems like in this case, all of the analytical work that the 60CA's opinion is doing is flowing from this 2C idea that the extraterritorial powers have to be authorized by the legislature. And so it seems like a lot of this case arguably comes down to, you know, what is the reasonable understanding of the exercise of extraterritorial power. You know, when you're going in and trying to enforce the law in another jurisdiction, or you're using your coercive authority to do searches, et cetera, you're kind of, you know, exerting your power into that jurisdiction. I don't know that it's reasonably kind of that one would reasonably understand the concept of exercising power in another jurisdiction to include just taking someone who you could have done the breath, you know, you could do the breath test in your own, you could do it there, they're under your control. If the city, maybe they can save money by having a facility in the city next door. Like the idea that constitutes kind of, in the constitutional sense, an exercise of power, to me seems like a stretch.
Yes, so I think that's correct, Your Honor. So when we talk about an extraterritorial exercise of police power, like I said earlier, I think what we're talking about is a police officer who goes to another jurisdiction and tries to start enforcing the law there, arresting people there for crimes committed there, which is a far cry from what we have here.
Could I ask you about these constitutional issues? Just the way that developed in this case. Were those issues briefed or argued in the district court, as far as you know?
I believe so, yes. So
I know it's in the opinion.
The issue of the exercise of extraterritorial authority, yes, my understanding is that was.
Well, I'm talking about the constitutional issues.
No, so I mean, they talk about the color of office doctrine, which is my understanding is the terminology.
But in the briefing, very simple question.
Yes.
And if you don't know, you don't know. But I've looked at the briefing, and it did not appear to me that the constitutional issues, and I might have missed it, that the constitutional issues were actually briefed. And we had two sets of briefs. We had the briefs that were originally filed and then supplemental briefing, but the ordering the supplemental briefing said nothing about briefing constitutional issues. It talked about briefing if there's statutory issues and other things related to the color of office. So all this discussion about the parameters of the Constitution, my question is, was that something that was actually briefed for proper consideration by the court?
I see. Well, so I think, so the 6th DCA, basically I think the issue was framed, I mean, it is framed as a statutory issue because what the Constitution says is basically that this is a statutory question.
Why are you saying that? I mean, the statutes can limit, I mean, it's kind of like, it's like local government law 101. Is if you look at 2B, municipalities shall have governmental, corporate, blah, 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 power, perform municipal functions and render municipal services, and may exercise any power for municipal purposes except as otherwise provided by law. So it seems like, I don't think that there's anything in the statutes that's been invoked here that's saying explicitly you can or can't do this. As I read the 6th DCA, all of the work is being done by this inference that if a municipality is exercising quote unquote extraterritorial powers, that has to be authorized by the legislature. But I don't think that a reasonable understanding of the exercise of extraterritorial power is equivalent to anything that a police officer does outside of the city that they're, in this case, the city that they're employed by. I mean, it seems like that's not a statutory question. The 6th DCA was essentially, whether they explicitly say this or not, they're interpreting this phrase in the Constitution, and I think that because there are these other cases where it talks about conducting searches and arresting people outside your jurisdiction, they're sort of by analogy, either assuming or, they're kind of drawing an inference that reading this consent thing and instructing, because really the request is made of the person administering the test. It's not really a request. It's a little vague as to who's requesting what from whom. But, all of the work here is basically trying to, by the 6th DCA, is sort of trying to fit what's going on here into the same thing as like going into another city and knocking on a door of a home or evidence that's in there or a person that's there sort of organically, rather than this situation where it's arguably just very different. And it's certainly more, it's not in the kind of like core of an exercise of power. I mean, I'm not saying that it's crazy to characterize it that way, but it's on the fringe at best of an exercise of power.
Yes, so I think we agree with that. So, I mean, our argument is that I guess this is not really truly an exercise of extraterritorial authority within the meaning of that constitutional provision, because he was enforcing the law in Maitland.
And let's go back to the informed consent statute. Now, if you look at 316, 1932, it talks about the administration of the test being incidental to a lawful arrest,
right, and
administered at the request of a law enforcement officer who has reasonable cause to believe that the person was driving under the influence. Well, isn't there kind of an irresistible implication here that at least ordinarily, not necessarily always, but at least ordinarily, that reasonable cause is going to be possessed by the arresting officer?
Yes, that's right, Your Honor. And in fact, if you look at subsection 1D, It says if the arresting officer does not request a breath test, the defendant can ask him to, and in which case he's required, the arresting officer is required to request a breath test. And I take it under Mr. Reppel's view that if the breath test facility that services his jurisdiction is not in his city, he just has to violate the statute, or else he can do it anyways. And I suppose the defendant can wait to see if the breath test results are good for him, then he can admit them to evidence, and then if they're incriminating, then he can object and have them suppressed. I do just want to briefly touch on the suppression issue. I mean, even if Your Honors were to think that this required a mutual aid agreement or something to that effect, I mean, clearly there was an arrangement between Orange County and the Maitland Police Department here.
From a preservation standpoint, I know you say that it was raised at the 6th, but why shouldn't it not have been raised at the trial court?
Yeah, so
after all, motion to suppress.
So there's a rule that stems from this court's decision in Harvey in Florida that you don't have to make a futile objection.
So I didn't read that case the same way. I think when it's talking about trial court, I don't see that language. It was more of a narrow ruling, I think. Due to the interest of justice, judicial efficiency, and unique circumstances of this case, we permit Harvey to raise his Heggs error as fundamental sentencing error for the first time on appeal. That seemed to be a pretty narrow ruling. Generally, you would agree, though, that the preservation issue is the issues raised in the trial court, right?
So I think, I actually think Harvey is exactly the situation we have here. You had a DCA opinion foreclosing the argument. So it was a single subject challenge to the sentencing guidelines. There's a DCA opinion rejecting the challenge. They raise it, this court ends up quashing it. In fact, it's arguably even more, I mean, in that case, that DCA opinion was pending before this court.
And what's the purpose of the preservation rule?
So the purpose of the preservation rule is to give the trial court the opportunity to address the question.
And if the trial court has no flexibility, because the law has already been established by a decision in the first DCA, the purpose of the preservation rule just doesn't come into play.
That's correct, Your Honor. So the trial court would have had no opportunity to even consider the exclusionary rule point because the DCA, binding DCA precedent foreclosed it.
And do you think the first DCA was truly that binding? I mean, do you think it was it was on all fours with the issue that was raised in the motion to suppress?
So yes. So I think, I mean, both the first DCA and the second DCA and the Collins decision had held that evidence that a police officer obtains outside their jurisdiction must be suppressed. We don't think there's any basis for that in any statute or the Constitution, and this court shouldn't create that remedy.
And it's also the case, isn't it, if I understand correctly from reading the opinion, that the 6th DCA thought that issue was properly before it because they addressed it.
Correct. So the 6th DCA in this case held that suppression was the proper remedy for this sort of violation.
You can have 15 seconds to finish up.
Yeah, so on the exclusionary rule issue, we ask that this court reject any invitation to expand the exclusionary rule further. Thank you.
Thanks, and you can have 2 minutes for rebuttal.
May it please the court, Stuart Hyman on behalf of Brian Reppel. Your Honors, this case has, in my opinion, become more complicated than what the actual issues were in this particular case. This case was based on both a violation of a statute, our position, and also the unlawful use of the color of office by a police officer outside of his jurisdiction. Those were the two issues that went to the 6th District Court of Appeal. There were also the same two issues that went to the 5th District Court of Appeal, albeit each District Court of Appeal had a different manner on how they handled the situation that was presented to them and the legal issues that were involved.
Let me, and this is related to what you're saying, were these constitutional issues that we've been talking about municipal powers, were those briefed in the 6th District?
I don't believe so.
Yeah, that just came up. That's just something that came up in the 6th District's opinion without any briefing. There's a lot of briefing here. You had 2 rounds of briefing, but that was not something that they asked to be briefed or that the parties actually briefed, correct?
I don't believe that constitutional, where it came into play, I believe, was dealing with the breath test and the breath test being a search. And I think that's how it kind of got meshed in with everything else, because it's been pretty much acknowledged that whether it requires a search warrant or not, blood requires a search warrant, breath doesn't, it's still a search. And I think that's been the jurisprudence of this state.
But that's an issue not about the constitutional provisions related to municipal power, but about search and seizure, right?
Yeah, I think the only reason it came into play was because of the allegation of the unlawful use of color of office, because it was a ferreting out of evidence, because it was a search and it was done by way of an implied consent warning, which is under Florida Statute 316.1932, which requires certain parameters as an alternative to the traditional scientific predicate for scientific evidence. But the legislature passed the implied consent law with the idea that it was going to be a shortcut to the admissibility of scientific evidence in breath test cases or UI cases. So I think what happened here was that it started off statutorily, and it also involved the unlawful use of color of office. And when I say statutorily, I think Florida Statute 316.1932, and again, if you subscribe to a supremacy of the text type of argument or interpretation of statutes, Florida Statute 316.1932 specifically says that only a law enforcement officer can request a breath test.
Can you kind of play that out some? Why is it, this is incident to a lawful arrest. It was at the request of a law enforcement officer. There's no limitation in the statute itself as to the jurisdiction of the law enforcement officer. And I think your argument is that by using the term law enforcement officer, the legislature is necessarily limiting to that to an officer who has authority to act within that jurisdiction.
And the reason why I agree, but you have to take it one step further. It's been, at least my understanding, even in the 5th District Court of Appeal, in the Griffiths case, when a municipal police officer ventures out of their jurisdiction, they are not considered, at least by those decisions, to be a law enforcement officer per se. They become a private citizen.
So when this officer was taking the defendant here to jail, when he crossed out of the municipal jurisdiction over into the county, he was no longer a law enforcement officer. He was a private citizen taking the defendant to jail. Isn't that the implication of what you're saying?
Well, Your Honor, the implication of what I'm saying is that I see cases that may be outcome legal analysis derived, because you can find cases that say that if a battery on a law enforcement officer occurs outside of that officer's jurisdiction, it can still be prosecuted as a battery on a law enforcement officer. But the premise for that, I'm not really sure has ever been addressed like it's been addressed in this case, is like, where does the source of that authority to be a law enforcement officer in another jurisdiction when you're a municipal police officer come from?
Well, let me, okay, so you are actually questioning, if I understand you correctly, correct me if I'm not, but you're questioning the authority of the Maitland police officer to go out of Maitland to take the defendant to jail. Once he's you question whether he's got that authority to actually do that, correct?
To some extent, but not really. And here's where I think the differentiation is. A police officer, in my humble opinion, is that they can, if they're started an investigation in Maitland and they need to go over to Winter Park to go look at a site or anything that doesn't involve evidence gathering. They're using their own senses to do that, their sense of observation, vision, whatever.
But that's evidence gathering.
Well,
it's still gathering evidence if I use my eyes or if I have a subpoena.
It could be.
It can't not be.
Well, you're allowed as a private citizen to go into other...
That's a different question. What you were saying a moment ago is that if they go to gather evidence by their own observation, the question is whether a law enforcement officer ceases to be a law enforcement officer when he or she gathers evidence outside their territorial jurisdiction. And it seems to me that there's no way for you to credibly make that assertion and also have a law enforcement officer, say, have the authority to serve a subpoena outside the jurisdiction for a witness, to go to the bar where Mr. Reppel had been, or let's say in this case the restaurant was not in the territorial jurisdiction of Maitland, and he goes to serve a subpoena there the next day to get the bar receipt or something like that. You would say that that's trampling on the statutory limitation. He's not being a private citizen, couldn't serve a subpoena and demand or search warrant. I mean, like, the rule you're propounding means that a law enforcement officer cannot investigate outside of their municipal limit.
Frankly, Your Honor, if that would be my position, but I'm trying to weave all this in amongst a lot of decisions from a lot of different courts going a lot of different ways. And the only way I have been able to make some semblance of legal reason out of it is that as long as it doesn't involve the use of color of office, where you're acting as a police officer to gather that evidence by, like in this case, an implied consent warning, saying that if you don't submit to a breath test, you're going to lose your license or you're going to be charged with a criminal offense.
Well, it's even clear under the statute that the warning actually has to be given by the officer. Now, the request has to come from an officer, but is it really clear from the statute that the warning? It just says the person shall be told. It doesn't necessarily say. You might expect it ordinarily it's going to be the officer, but does it actually say that?
Well, it doesn't actually say it, but it says a law enforcement officer. So it could be another law enforcement officer with jurisdiction there who could make the request.
It doesn't, well, the request is by a law enforcement officer, but the warning doesn't have to be, or the reading the notice. But let me ask, I mean, so could the law enforcement officer issue the consent notice and make a call to the facility outside the city and say, call the technician and say, hey, I'm requesting that you do this test, I'm bringing the guy over?
Maybe.
Okay, so I mean, this is ridiculous. I mean, you know what I mean, really, this makes no, I mean, I understand that sometimes we have to do things that make no sense, but this just seems like we would have to be going out of our way. In this case,
I don't believe we're going out of our way, and I think.
Okay, tell me why that is.
Argument.
The reason why I don't believe we're going out of our way is because, and I go back a little bit longer, but there was a time when every municipality I know of in the Orlando area had their own breath testing machine in their city. Somehow this evolved to where it was outside the city. But there's no reason why a police officer, if we're concerned about a municipality and the enforcement of their laws in their municipality, there is no reason, just like they go out and buy police cars, they go out and buy radios, they can go out and buy a breath testing machine. And that breath testing machine would be within the city limits of that jurisdiction. That police officer could enforce the laws of that municipality, arrest somebody for DUI, and take them down to their station and submit them to
really,
a breath
I mean,
test.
you can imagine the whole thing with the extraterritorial exercise of power. You can imagine part of that is based on not wanting to interfere with the law enforcement activity of the law enforcement people for the other jurisdiction. Part of it could be protecting the citizens and the property in the other jurisdiction. I mean, in this case, neither one of those interests is really at stake. I don't understand. I mean, this just seems like a completely, I mean, I hate it when every time someone uses the word formalism that it's in a pejorative way, but this does really seem like sort of an empty thing. If there's nothing inherent about anything that this law enforcement officer is doing, it's not inherent that it has to happen in the other jurisdiction for it to be effective. You could make your call, you could do the warning and make the call in the thing. You're dealing with a crime that was committed in your jurisdiction. It could be, you know, the person was there. I mean, what is the point? I don't get it.
The point is that once you bring the breath test into it, it's a whole separate offense in a lot of respects. Because first off, they're requesting a breath test which for the charge of unlawful breath alcohol level, which cannot be made in the city of Maitland unless there's a breath testing machine in the city of Maitland.
But all of that is incident to the arrest. It has to be incident to the arrest. It flows from the arrest, right?
Not as of October 1st, I don't believe it does, but it actually be a little bit before that when refusals became a crime.
Well, yes.
Well, but we're, okay, that you can talk about the current law, but that's not really what we're here on now.
Well, that back then a second refusal was a crime.
Right, so that's what I was exploring with the state, right? Like if we make it battery on a law enforcement officer instead, or if, let's say your client had instead threatened witnesses, it sounds like the state is saying that the narrowest rule that they would espouse would actually leave you in the right or perhaps leave the question open. But I don't see a way to decide this case that narrowly. I think that what the state is really saying is that if another crime comes to light while a law enforcement officer is investigating the conduct that generated probable cause in the first place, then it would be formalistic and also contrary to the Constitution, both our state Constitution and settled principles of U.S. Constitution search and seizure law, to have the law enforcement officer either turn a blind eye to the evidence or somehow have to say, I'm without my jurisdiction. I'm going to not detect and enforce a violation of the state law that I was sworn to uphold just because now I'm outside the territorial limitations of the city of Maitland.
Once they go outside the territorial limits of the city of Maitland, they're a private citizen just like any other private citizen.
I'm glad you're making your argument clearly because it allows me to assess it. I think the argument that once a Maitland police officer leaves Maitland, he's a private citizen or she's a private citizen no matter what, is not an argument that prevails under our case law, but I admire your your clarity.
Mr. Hyman, do you think that there is some distinction, especially in the case law, about whether someone is in custody? Because to me, that's very different. I think I agree with you that if a Maitland police officer goes and attempts to arrest someone they see committing a crime in downtown Orlando, that we have a very completely different question because I think that's something that pretty clearly is exercising some sort of extraterritorial power that doesn't belong to a private citizen in any way, or and probably is not something that we would find would be authorized by statute. But in this case, you have someone, and in fresh pursuit, that includes arresting someone outside of your, it's very specific. It's not about someone already in custody. Most of the laws have to do along with when you're sort of asserting that level of authority outside your jurisdiction. But here we have someone who has already been arrested. They're being transported. I mean, I don't think you're arguing they can't be transported and booked at 33rd, correct?
Well, I don't. They can be booked at 33rd.
Okay,
yes.
all right. So the officer has to transport them. They're not going to let them walk there, and so they're getting there. And I think kind of the point is that they're already in custody. They've already been arrested. It was a lawful arrest, and I don't know that we really have anything that has ever clearly defined that particular situation.
I think we can also lose sight of the fact that under Florida Statute 322.2615, which is the administrative suspension law, which is another part of all this, under the administrative suspension law, the police officer is acting on behalf of the state of Florida. to suspend a driver's license for somebody who refuses or registers an unlawful breath alcohol level. What's really, there's the Florida Highway Patrol. They have jurisdiction all over the state because they're state officers. The legislature has given the university, as for instance, Central Florida, the authority to go ahead and enforce the law. But it's all legislative authority that's giving these police agencies their authority to do what they do around the state.
What's your understanding of how the mutual aid agreements are working in this scenario in practice?
In practice, they can work. The problem is that I believe, this is just me, for whatever it's worth, I believe they were really intended for special events. The president's coming to town, there's a hurricane, there's some kind of big emergency, and then all the departments want to get together and form a mutual aid agreement so that they can all assist each other in that kind of situation. But I think for routine law enforcement matters, I just personally don't see it legally as being something that should be done. And this is a routine, even if you look at some of the others.
So what you, well, help me understand what you think should be done. Do we go back to your view that every little municipality ought to have their own testing, and they do the testing there, and they don't, these central testing facilities?
I throw that out as one alternative,
Okay.
but I
Now,
can think
that would be good for you and your clients, I'm sure. And you would agree, right?
if they did it in their
Yeah,
own
in every
jurisdiction.
little burg, they're doing it because it's more likely to have some technical problems. Isn't that correct?
I won't say that can. I won't say that can happen, but I would like to think that whoever's in charge of those devices, which I know from experience, there has been many very capable individuals in little cities that.
Well, I'm sure that in many little cities it would be done perfectly, but the more people that are doing it and the less frequently they do it, the more likely that there's going to be some failure, correct?
You don't avoid that problem, though, the way they're doing it now, because you have probably, I don't know, 20 or 30 technicians.
Okay, well, I've caused a digression here, but so, but basically, you just think that there's got to be something done differently. Mutual aid pact, you don't think that's a solution, but for the reasons that it doesn't really seem to fit what we're talking about. So if it's not having the testing everywhere, what is it?
Here's what I think. This is just what I think, that we have laws of jurisdiction for a reason. They're there for a reason. You can't even get into court unless the court has jurisdiction. Jurisdiction is like one of the basic premises of anything we do legally.
Well, yeah, okay, so a court's subject matter jurisdiction stems from, under the U.S. Constitution's power to decide cases of controversy, from our Constitution, different, That's different from the jurisdiction of a law enforcement officer to enforce the law. One is let's be careful about our analogies, right? When we speak about a court's jurisdiction, we're talking about one power, the judicial power. Yeah. We're now talking about the executive power, right? Which is a different, same word. Let's talk about authority or jurisdiction carefully, right?
Well, I think that you need to go back to the statutes that provide jurisdiction. The legislature could fix this. They've fixed a lot of other things over the years in this field, and it could be fixed. But the way they have written that the implied consent statute is that a law enforcement officer has to request the breath test. The jurisdictional law on municipal police officers, there's numerous that I've cited in the brief, and there's probably more even out there, that once a municipal police officer leaves their jurisdiction, they're a private citizen. And if we're going to give the text of that statute what it says and what it means, and I'll call maybe the court's attention to the Griffiths case, which is also from the 5th District Court of Appeal case. In that particular case, it dealt with search warrants, and under 93307, the service of a search warrant, whether a search warrant could be issued and who it could be issued to. And the statute required to be issued to a law enforcement officer, actually used police officer. But the Fifth District Court of Appeal in that opinion made a point of saying that it had to be a police officer with power to act. They made a specific finding, power to act. So in this particular case, if the legislature is going to use law enforcement officer in Florida Statute 316.1932, it has to be a law enforcement officer, my opinion, with power to act if we're going to be consistent.
Can I clarify one thing on the suppression issue? So on the suppression issue, can you clarify your argument? Is it that you think it's a legislative statutory suppression remedy, or do you think it's constitutional in nature?
I believe it could be delved in constitutionally if you look at some cases where statutes don't expressly say suppression is the remedy, because there are cases that you say you go back to England, and what was it back in England? And I think they even brought up in one of the opinions that the constables used to have the king's coats, and if they were doing acts without the king's coats, they weren't lawful. So, I mean, you can make that analogy and go back and find a constitutional remedy of exclusionary rule. But I think when it comes to the implied consent law, it has always, even by this court, held in those three cases, Robertson, Donaldson, and Bender, to be statutory. And it was a statutory exclusion. If you didn't comply with the requirements of the statute or the rules for the administration of the breath test, then there was it said in Robertson, a statutory exclusionary rule. And so I believe it is a statutory exclusion, but I believe that the argument could be made it's constitutional as well.
I guess I'm just trying to figure out which one you're hanging your hat on.
Yeah, I really would like to say I'm hanging it on one or the other, but I'm not really, because I can see the arguments for both of them. And I don't make the decisions, I just kind of follow them from different courts and try and put them together and come to some sensible conclusion legally that makes sense legally. And I do believe, though, when they say that the three cases out of this Florida Supreme Court in the past, Donaldson, Bender, and Robertson, they were all very basic in that you have to comply with the statute, and there's a statute involved in this case on 316.1932 that it has to be a law enforcement officer that requests the breath test. So I think the better argument probably in this case is statutory suppression by the exclusionary rule that's statutory. But I think the argument could also be made that it is based on the Constitution. If you want to go back to what is the powers of police officers and evidence gathering, and back then I guess it was breaking down doors because they didn't have breath test machines, but here we have breath tests where people are being searched personally. So my feeling is that I can't make the decision, but I think there's an argument that could be made for both of those, but I think the statutory one's probably a better argument.
And in order for you to win on the merits, we have to there's other parts to it, but the foundational premise is that the act of requesting the technician or whatever to perform the test, that is an extraterritorial exercise of municipal power.
Yes, and it's being done not only for the officer for his DUI case, but it's also being done on behalf of the state of Florida for administrative purposes as far as the suspension of driver's licenses. They're acting as a state officer.
And we don't really have, other than just sort of the analogies to the sort of non-kind of observational sort of walking around type searches, there's no, I'm not aware of anybody citing any authority for kind of understanding this phrase in the Constitution in this context to address. I mean, it's all by analogy to.
I'm not sure I understand the color of office.
Well, I'm just saying. I mean, the reason why you're arguing that it's the authority that you have to say that this is an. I mean, one is that you're just saying as a matter of language they're quote unquote exercising power, but as far as analogizing it to other things that have been legally recognized to be the extraterritorial exercise of power, like we know you don't need a statute if a policeman from Maitland wants to go walk around in another city and gather evidence that's relevant to a case, you don't need any legislative authority to do that, right?
Well, if you follow the premise that if that's actually evidence gathering by walking around and just using your eyes, then yes, you probably do.
Okay, well that goes, okay, I don't want to, but that's obviously, that goes against the case law.
What I analogize this to is those cases where they went to hotel rooms and searched hotel rooms. They went to people's houses and did searches.
Right.
That's where they're using the color of their office.
Right, I understand. So that's basically, it's okay.
Can I ask a brief follow-up about the request for the test? Do you understand that to be a request that is made by the officer to the technician to administer the test, which I think what the chief suggested, or a request by the officer to the person in custody, the arrestee, to submit to the test?
I think it's a request by the officer who arrested them to submit to the test.
So it's not a request to the technician. That's your view anyway.
Yeah, and not only that, but like in this case, it wouldn't have been possible because the technician's a civilian. They don't have authority to go ahead under that statute.
Well, but I understand the request has to emanate from
the police officer.
From the police officer. No question about that. The question I have is who the request is directed to. Is it directed to the technician to administer the test or to the arrestee to submit to it? You say to the arrestee to submit to it, correct?
Yeah, it just kind of, I guess it gets it under, it's more of an understanding that when they go down there, the technician's going to do the test and the police officer is going to read the implied consent warning and request the test. That's
yeah, but the statute's all over that. I mean, they talk about different people requesting different things. It's not obvious that the recipient of the request is the defendant or the arrestee, because I mean, the whole premise of this is that they've already consented. They're just kind of being reminded of the consent that they've already given, and they're being kind of warned that if they withdraw their consent, there's going to be these potential criminal consequences. So it's a strange construct. Like it's not even really analogous to knocking on a door and saying, can I come in? Because obviously I haven't already consented to someone coming in that situation. So it's a very, I mean, I understand why you're arguing what you are. I'm not criticizing you, but I mean, this is obviously kind of, this is its own sort of unique thing that doesn't really fit, it doesn't fit the other practices that are out there.
I'm sorry.
Go ahead.
It could become a slippery slope, though. Because depending on how this goes, does that give police officers the authority from Maitland to come to Tallahassee and go ahead and interrogate people up here by use of the color of their office? Can they come up here?
Who haven't already been arrested?
Maybe they were arrested and they were out on bond and they come up here to gather more evidence. Where it could go is a lot. That's why I would submit it's a slippery slope.
Okay, you can have 30 seconds to finish up.
Okay, but I believe that if we just go by the case law that's developed foundationally, as I understand it, a municipal police officer outside of their jurisdiction is a private citizen, and they cannot use the color of their office to ferret out evidence that's not otherwise observable. And I believe it comes down to that and a statute to support that in Florida Statute 316.1932, that it has to be a law enforcement officer that's requesting a breath test, and that's what I believe it boils down to in the end.
Thank you very much.
Thank you. Thank you.
Just briefly, if I understand my friend correctly, he's now principally arguing that this is actually a violation of the implied consent statute. I think that I don't think you can get that from the implied consent statute. The implied consent statute authorizes, and indeed some cases requires, the arresting officer to request a test. My take of my friend's view is that the legislature was implicitly requiring every municipality in the state of Florida to purchase their own breath test and operate their own breath test facility. I hate to invoke the absurdity canon, but I feel like we're approaching that territory. I mean, there's some municipalities in Florida that have agencies of just a handful of police officers. I don't think the legislature was requiring that. Regardless, this is not anything that goes to the accuracy or the validity of the test results themselves, so there's actually nothing in the implied consent statute that would require suppression in that context. Thank you.
Thank you. Okay, our next case is Guzman versus State of Florida, number 2024-1191.
May it please the court. My name is Valerie Lennon, and I represent the appellant James Guzman. At this time, may I reserve 5 minutes for rebuttal? The central issue before the court today is whether the resentencing judge should have disqualified herself after it was revealed that she worked for Mr. Guzman's original appellate attorney in 1994. It became apparent during the proceedings she was notified by Mr. Guzman's original appellate attorney that she worked for him as a young associate.
Can we just go to the text of the rule? So 2.330E, a motion to disqualify shall set forth all specific and material facts upon which the judge's impartiality might reasonably be questioned. Okay? And then it says, including but not limited to the following circumstances, and then, and only then, do we come to 3. The judge served as a lawyer or was the lower court judge in a matter, in the matter in controversy, or a lawyer with whom the judge previously practiced law. So it seems to me that you can't get to 2330E3 without going through 2330E, the sort of predicate language, which says and qualifies everything that comes after it to be a material fact upon which the judge's impartiality might reasonably be questioned. Do we agree so far or no?
No, it says or. Under 1, it says or.
Which or are you
Subsection
pointing me to?
1E1, it says or. So if we look at the rule grounds, it says a motion to disqualify might reasonably be questioned, including these grounds, but not limited to.
Right. I guess my point is, I'm sorry, I don't see the or you're talking about. What I see
think
instead,
I was reading the next section.
Okay.
Okay, sorry.
So E3 stands alone. Just stick with me for a minute.
Sure.
E1 is a ground that's not at issue. The ground at issue, do we agree, is E3?
Correct.
Okay. So the ground articulated in E3 has to be a basis upon which the judge's impartiality might reasonably be questioned, right?
Yes.
Okay. So whatever we think about whether let's stipulate that the judge in this case was a lawyer with whom the judge previously practiced law, right? That relationship exists. We still have to read that through E, which says it has to be a basis upon which the judge's impartiality might reasonably be questioned. Do we agree?
We agree.
Okay. So now make the argument how this judge, having been a junior associate with no contact on the defendant's own case at the law firm, might be reasonably questioned in her current capacity.
The rule is not concerned, so let's be clear. The constitutional amendments are concerned with actual impartiality.
I'm not talking about that. I'm talking about this rule.
I know, and I'm making the distinction. These rules, including this rule and the judicial canons, are concerned with the appearance of bias, not actual bias, but the appearance. So it's the public perception.
Help me understand who would perceive this judge who worked at the firm, worked with a lawyer as a junior associate with absolutely no contact on the file. is somehow might be perceived by anyone as biased against the defendant.
The public perception is what we are concerned with here, not actual bias.
I understand.
It's
I'm
the
asking you to
perception.
articulate what is that perception?
The perception is that whether she had actual bias or not is that she had inside information. That's the way law firms work, is that we have behind the scenes conversations. Oh, I just got off the phone with the defendant. He said this. This happened in the courtroom as we were walking out. Those are the sort of conversations that happen off the record, outside the courtroom.
Is there anything in the record to suggest that that's what that's what was alleged here?
No, Your Honor.
Okay.
But again, it's not actual bias that we're concerned with. It's the
But
perception.
you have to have a legally sufficient basis to make this. Point to me in the affidavit where there was a legally sufficient basis for what you just said.
The legally sufficient basis is in the rule itself. The rule is
Well, that's not what we
self-executing.
require. You have to. There's an affidavit. Show me where it is in the affidavit that they filed with this judge and said, this is the legally sufficient basis on which you have to disqualify yourself. Where did they say all of the things you just said?
I don't have the affidavit in front of me, but the basis is that you worked for the lawyer, you worked for the law firm. It's the same case and controversy, the same parties, the same indictment. That right there was enough that the judge should have recused herself without the motion.
But isn't it also the case that this is a de novo proceeding? I mean, it's like, no?
No, this is the same proceeding. It's the same indictment from 1991, the same parties, the same defendant, the same cause of action. It's not a de novo proceeding. It's same case and controversy.
But resentencing is, I mean, understand it's related. I mean, obviously, in that sense, it's the same overall case. But this is a new. It seems like to me to be a new matter because of the fact that you're starting over. What happened what happened earlier, other than conviction, obviously, but in terms of the sentencing, which is what is at issue here, it's a fresh slate. It's got to, and so that what you're saying is that the theory here is that, well, maybe the judge knew something bad or good from that earlier, those earlier things going on, and that will have an influence on her from things outside the record.
That the public perceives that she might have known something that affected any of her rulings in this matter.
What about, let me ask you, I mean, we're dealing here with a smaller firm, am I correct?
It is a very small firm, not a large law firm.
And what the judge did when she worked in that firm, she specialized in evictions and divorces, I believe?
I believe that's what she said on the record.
But what happens, like, say some of these Miami firms that have like 200 or 300 lawyers, 5 or 6 floors on a huge building, and the lawyers don't even know each other, most of them. Would the same principle apply?
Yes, Your Honor.
Now I'm on the 22nd floor, and somebody up on the 5th floor is handling the case, and all of a sudden I have to recuse myself. Does a perception apply there too?
Yes, Your Honor. The rule doesn't contain those limitations. It doesn't contain a time limitation. It doesn't contain a knowledge limitation. All it contains is association. That's all it says, association. It doesn't say that the lawyer or that the judge has to recuse herself if she had knowledge or if she worked on the case. It just says that she associated. So if I could bring up the case that the state filed as supplemental authority, the Street case, which we can automatically, aside for the factual scenarios, eliminate the federal cases because it doesn't contain a similar provision as subsection H. In the DeTemple case, which was a bankruptcy case that ultimately turned into a criminal case stemming from the bankruptcy case. So the judge in that case had been a debt collection attorney in the bankruptcy case. This, and this happened. It ultimately turned into a criminal case. What the Fourth Circuit said was that that judge should have recused himself from the case.
But the thing is, that would require any prosecutor who goes on the bench to recuse themselves from any cases, or any public defender who goes on the bench. That would require them to recuse themselves, wouldn't it?
Not necessarily.
Why?
So it wouldn't, because, again, going back to same case and controversy, we're on the same indictment from 1992. Same defendant. It's still the state versus James Guzman. If that prosecutor at any time had worked on state versus James Guzman, then he would have to be recused or disqualified.
But okay, you say if he worked on it. But you're saying here whether she worked on it or not doesn't make any difference, right?
According to this rule, it doesn't. But in the factual scenario from the DeTemple case, they allowed the judge to stay on, saying he should have recused himself. It's harmless, given that all of this had happened. The debtor was not a party to that criminal case.
Justice Labarga's question is, how is what you're saying different than a public defender or a prosecutor having to recuse from any case, even those they didn't work on?
Well, unfortunately, that is one of the reasons that we are 34 years later here in this case, because the public defender did have a conflict of interest in this case back in 1994. That was the original appeal.
I think what Justice Labarga is saying is, if a prosecutor or public defender becomes a judge, why would they, under your theory, not have to recuse from essentially every case if the defendant had been prosecuted while they were at the office?
If I understand the question correctly, then it becomes, it's the association rule. The rule says the
prosecutor is now a judge, recuses off every criminal case that if the defendant had ever gone through their office while
because
they were
a lawyer
there.
with whom I worked is now counsel in this case, and I am associated with that.
Then that's a different scenario. But here we're talking about a very small firm. In this case, this was a small.
Is that in the affidavit, the size of the firm? I mean, I think going back to the legally sufficient, and what the affidavit has is that she was employed at this firm, and the firm had a case. She advised she was not working on the appeal. That's all the judge has from a legal sufficiency standpoint. So you keep adding all these wrinkles to help the argument, but from a legal sufficiency standpoint, why are those 3 points sufficient to cause reasonable doubt?
That's all the information we have. That's all the judge gave. That's all the information we have. The collaborative nature of law firms is that we share information behind the scenes. We have discussions behind the scenes. That's just how law firms work.
Just think of the practicality of what you're suggesting. Let's say Miss Millsap joins the Florida Supreme Court. Under your argument, she could not preside over any case that existed in her office at the time that she worked there.
Well, she certainly couldn't preside over the Guzman case if she joined the
Florida
Supreme Court.
I don't know, but what I'm saying is any other case that the AG was working on when she worked there, she could not preside over.
So certainly my argument would be taking it to the extreme there, and it would have to be a little bit more fact specific. But the rule itself is concerned with preserving the public's trust in the outcome of the proceeding, the fairness of the proceeding, the impartiality of the proceeding. That is what the rule is concerned with here.
Well, I mean, this business about your focus here is on the public. But isn't all this about recusal about the defendant's reasonable perception that the judge is going to be biased against the defendant, not about what the public thinks? Isn't that right?
No, Your Honor, the rule is concerned with the rule is an objective standard, right? So he has to make a legally sufficient motion. That's his perception, right? But the ruling is based on what the public perceives. It's not based on actual bias.
It's based on reasonable perception, but I mean,
until we
every case I've seen like this where somebody's trying to get a judge recused, it's like I the defendant, think I'm not going to get a fair trial because the judge is biased against me or biased against my attorney or something like that. It's not because the public is going to think this is not a good thing.
As long as he states a legally sufficient motion, then we get to subsection H, shall not pass on the truth of the facts alleged. So if he states a legally sufficient motion. I
understand that. That's not what I'm talking about.
He did state a legally sufficient motion. She worked for the attorney in a small firm. That is a legally sufficient motion.
So you're saying he doesn't have to show there is potential bias. He doesn't have to show a reasonable person would be concerned about bias. He has to make none of that claim. All he has to put forth to reach what you're saying is legally sufficient is that she worked in a law firm 30 years ago, even though not on his case.
He's clearly met the requirements of subsection E3. She worked in association with a lawyer that represented him on the same case and controversy. That meets E3. Then we get to go to H. Shall not pass on the truth of the facts alleged if the motion is legally sufficient, which it was. The judge shall immediately enter an order of
That's what's at
disqualification.
issue here, right? I understand your position as it was, but that's what we got to decide.
Correct, Your Honor. It's whether the motion was legally sufficient. And our position is that it is. It was a small law firm. It's the same case and controversy. She worked for the lawyer that represented him. She would have been privileged, whether she remembers it or not. And to the state's position, she said that the briefs had already been filed when she started working there. The representation and communication with the client does not end when the briefs are filed, certainly not in a death penalty case. I will speak to Mr. Guzman when I leave here today. After the briefs are filed, we go to oral argument. And in death penalty cases, the communication with the client is continuous. It wouldn't have ended when the briefs were filed. So to that end, if there are no further questions from the court, thank you.
Thank you.
May it please the court, Assistant Attorney General Charmaine Millsaps. I would like to start with the actual motion and what was in the affidavit, because the argument being made here, based on E3, Rule 2.330E3, was not what was made below. What was made below in the affidavit was an allegation that the delay in disclosing this was what gave rise to the defendant's reasonable fear. That's what their argument down below was, that she didn't tell everyone about working at this firm. Well, the reason she didn't tell everybody is very clear from the recusal hearing. Judge Nichols was contacted after jury selection. She was emailed, Rose of the firm that she worked for, Rice and Rose, James Rose, sent her an email. And then the very next day she held a recusal hearing under the canons, and so she could inform them of this. But there was no delay, so there's no, and it has to be an objectively reasonable fear. And what they were saying their fear was based on this delay, but there was no delay.
Well, I guess they're asserting she should have known what this thing that happened appealed 30 years before somehow, or they somehow scurry, pour through things to figure that out.
Yes, and even if she remembered why I was there was some capital case that they were talking around the water cooler about. She's not going to remember Guzman and his name in any of that. There was no delay. This rule-based argument about the association itself was not what was made below. What was made below was her. Judge Nichols was assigned to this case in February of 2023, and then the fourth resentencing was held in March of 2024. So they were saying the delay in disclosing this, but there was literally not even a 24-hour delay from when she really learned of this, which was when when James Rose, of the firm Rice and Rose, who represented the defendant in the 1994 appeal, emailed her the night after jury selection, and she literally disclosed that the next day. I don't think the rule-based argument is even preserved, the E3 part of it. Now, but I do want to go ahead and give you three arguments on why I think this is too attenuated even under the rule. First is the sheer amount of time that has elapsed. Your Honor, there are very few cases that I could find about this subsection of the federal equivalent of our rule, which is 28 United States Code, section 455B2. It contains very similar language. I supplemented with, street is in my brief, and with the temple. And those involved 5 years and 10 years. This is 30 years later. And you can check your own docket about when these briefs were filed. And then secondly, this is not I couldn't find a single case. I better back up and explain to you. This language in the rule is relatively new. It was added in January of 2021. That's why I was going over to the federal cases, because there are no cases directly on this part about the prior representation in Florida case law. But I couldn't find a single federal case where this has been part of the rule for decades, that involved a non-adverse party. Every one of those involved an allegation where the judge had some sort of direct or indirect association with the opposing party. Her former firm that she worked for 30 years ago was Mr. Guzman's attorney. I don't even think after 30 years it'd be reasonable for the state to object. The state doesn't have a reasonable fear here after 30 years. And it literally was nearly 30 years. She started working in the firm in May of 1994, and this fourth resentencing that Judge Nichols presided over was in March of 2024. So it's literally that long. And then there is no involvement, and I think you can rely, because her statements were part of the recusal hearing before the disqualification motion was ever filed. She really split the recusal hearing in two parts. First was with the attorneys themselves, and then she also wanted to personally inform Guzman. So the next day she had Guzman appear via Zoom. But in between, earlier they filed a motion to recuse. But the motion to recuse was, I'm going to call it general and based on the delay. It wasn't based on this prior representation argument under the rule. And then the third, so I do think you can, as happened, and she said as part of that she had absolutely no contact with the file and no participation in the case at all in the recusal hearing. And you can rely on that because those statements were part of the recusal hearing before the disqualification motion had even been made. And then last, I don't even think I need to get to this, but this court does allow appearance problems, not actual bias, to be considered harmless. So rule-based appearance issues can be considered harmless. And I would point out 4 judges, 3 judges before her have sentenced this defendant to death. So there are literally 3 other judges that viewed this case in much the same way. And that's basically my harmless under Sexton argument. Thank you for your time. And we ask you to affirm the sentence following the 4th penalty phase.
Thank you.
May it please the court. I would point out that James Rose thought that the Resentencing Judges Association was significant enough to point it out to her. And then I would again point out that these federal cases are inapplicable and not even instructive because it doesn't contain a similar, or Section 28 USC 455 does not contain a similar provision to what we have in subsection H. And since there were no questions from the court for the state, I would ask the court to reverse and give a limited remand for resentencing in front of a different judge. Thank you.
Thank you very much. We'll be in recess for 10 minutes.
All rise.
I wish they had a timer clock kind of running, you know, like so. Because they are like, okay, 30 seconds for a public.
No, we had our phones. Nobody wears
I know.
watches anymore.
I know.
Hurry though.
They really are. They're library tables.
So I parked over at Plaza. So not too far.
No, just one. The next one.
Oh, nice. Headed right home. Your firm?
My children.
All rise. Supreme Court of Florida is now in session. Please be seated.
Okay, our third and final case this morning is Grove Isle at Vero Beach Condominium Association versus Universal Property and Casualty Insurance Company, number 2024-0764. Whenever you're ready.
May it please the court. I'm Debbie Macon with Lydecker LLP here on behalf of the appellant Grove Isles Condominium Association. Two members of the 4th District got it wrong. They failed to recognize.
I apologize. I'm having a little trouble hearing you.
Okay. Two members of the 4th District got it wrong. They failed to recognize that this amendment was only prospectively applied. Just 2 months later, the 2nd District Court of Appeals, with the benefit of the 4th's opinion, decided to rule the exact opposite way on parallel facts. That's the Laguna Rivera decision. There's a reason the 2nd District found that 627.714 sub 4 was only prospectively applied. The amendment here attaches consequences to events that took place after the effective date of the statute, which is July 1, 2021. Hence, there's no concerns with retroactive application. Now, you may be saying, doesn't this insurance contract exist before July 1, 2021? So just because certain events predate the effective date of a statute, such as the incepting of a policy, does not mean there was retroactive application.
What are the relevant, is the relevant event then, your position, is the accrual of the cause of action, that there are certain contractual rights that don't vest until the accrual of the cause of action, right?
Yes.
Okay, now help us understand, that would seem, if we take that principle to its logical extent, to include just about any contractual promise that depends on future performance. Where would you draw the line? And perhaps it's easier to draw in the insurance context because we need some sort of loss. But help us do that, because obviously all contracts, I shouldn't say all, most contracts are forward-looking in some sense. They require performance, and so there will be some expectation. And it would seem to me that we'd have to have some way to say these expectations, while perhaps not fully realized, are nonetheless subject to some, protection. Indeed, the Constitution says so, right? We have a whole line of cases about, not interfering with the obligations of contract, and that significantly doesn't speak to just terms of contract. It says obligations of contract, which means that the constitutional protection also attaches to certain forward-looking things, the performance of obligations. Can you help us draw that line?
So the way the courts, Florida courts have traditionally followed this approach is they've looked at what is the right that we are talking about. They've had to evaluate the nature and quality of that right. And so that gets us right back into, are we looking at this contract and researching for vested rights? And did subrogation meet that quality? And there are many tests here. We can go back to Knowles. We could go to Justice Kennedy's decision in RAM when he was with the second DCA, and it failed the test of vestedness.
Is what matters the fact that subrogation is as to a party alien to the contract? Like, help me understand what makes subrogation different.
So if we were going to look at an insurance contract and we're going to say, what is the benefit of the bargain? What's the purpose of this contract? Well, let's look at the primary. We want to make sure someone has coverage in their time of trouble. We want to make sure the insurer is paid. But who the insurer gets to sue on the back end, that's really an ancillary thing to the contract. Even the dissent in Grove-Viles recognized this, that when this policy is incepting, whom they're going to get to sue, when they're going to sue, what is the actual event of loss, all of these things are completely I'm sorry.
Sorry, no, go ahead. Can I just ask you about why it's a cause of action versus contractual? So I think the second DCA's position is that nobody has an interest in a cause of action. I think your argument now, if I understand it correctly, is that the right was not in the cause of action. There might be interest in what's policy language. But under this statutory change, a condo owner can still sue an association, right? There's still the cause of action is still live between the unit owner and the association. What's limited by the statute is what can go into an insurance policy. So why should we be looking at it through the lens of cause of action is yet to accrue versus what the statute appears to do, which is say an insurance policy cannot contain this language?
So it says it may not be enforced. What it is it's a conditional immunity, okay? And what Universal wants to say is, before we used to be able to sue everyone and their mother. Well, they can still sue everyone. The list of targets is still extremely long, okay? Mother may be off the table, and the reason I say may is it's conditional. Mother, being the association, is going to have to meet certain predicates before they even qualify for the immunity. So this is a third party that is well beyond this contract that is enjoying a qualified immunity. And it is enjoying immunity to something that really didn't even exist before July 1, 2021.
I think but I think the question though is your character. I mean, part of this, it seems like a lot of the case comes down to framing. You're characterizing the statute as if it's giving an immunity. I think another way to look at it is that the statute, the way it's written, is essentially regulating the contents of insurance policies. I think if you view it the latter way, which I think was the premise of the question, then really you don't even get to any of this vested right and when did things accrue and whatever, because if the statute is written in a way that it's basically saying this is what insurance policies may and may not contain, then at sort of step one, the first question that the court would ask is, has the legislature clearly expressed a desire to regulate already existing policy contracts? And here I think the answer to that would be no, and so the case is over. We don't need to get into any of this other stuff, which I think is the way the fourth DCA viewed it. And so I guess I think to respond, to kind of explain what's wrong with the fourth DCA and to answer the question, I mean, I think that's the point. The statute doesn't say from henceforth, after the effective date, such and such is immune from such and such. That would be kind of a different thing. We'd be asking whether the granting of that immunity took some right away that was vested or whatever. But the form of the statute, rather than being written that way, it was written to directly regulate the content of the policies. Why then do we not sort of at step one then look for the clear intent to apply that to already existing policies?
So the way it is written is it says you may not provide for a right of subrogation against a condominium.
But you left off the beginning. What's the beginning?
An insurance policy issued to an may not provide.
Okay. So explain why that isn't applying to insurance policies issued after the effective date of the statute.
So it is being applied on a conditional basis, okay? It is not invalidating subrogation clauses in policies, okay? Those subrogation
Well, it's invalidating it to a certain extent.
Well,
under certain conditions, it's a partial invalidation of those provisions in existing policy. That's how you win, okay? Right?
It's saying that they can have effect, but this entity, which is outside of this contract, they have a defense if they gave up something, okay? That's really what it is saying. And the reason it is really not going back and rewriting these policies, again, legislatures, they are presumed to know what the law is, okay? They know going in, once they put in this effective date, they are not supposed to be tinkering with vested fundamental substantive rights. What they're saying is, because this is in a way subrogation, it doesn't exist.
Isn't there just kind of, and this is a very complicated area, and I think both of you did a good job briefing it, and it's extraordinarily complicated, and you kind of, the way framing things is critical. But isn't there just kind of, and this is just following up on what the chief has already said, but isn't there something out there kind of in the atmosphere in this arena that if the legislature is going to go messing with contracts, a category of contracts, even just messing with them a little bit, that they need to make clear that they're doing that not just prospectively, but as to existing contracts. And that's kind of swirling around this. That's what the fourth DCA basically, I think, is what led them to where they got to, that threshold question about what the legislature means. But it's particularly an issue when we're talking about things that are in contracts, because the idea is that ordinarily if you got a contract, and you're good, and the government's not going to come in and say, oh well, you can't do that. That part of the contract's no longer any good. Now, I'm not saying that they can't occasionally do that, and that's always improper. But the presumption is that that's not going to happen unless the legislature says, yeah, we're coming in, we don't like those existing contracts, and we think it's against public policy and it causes all these harms, and we're going to undertake a regulatory measure to stop that. But that is not the way this is framed. This is focused on, as the chief said, it's focused on contracts, not so much as a regulatory matter about contracts. Do you see what I'm saying?
I do see what you're saying, but they have left subrogation intact. Let's look at the entire universe. They can still sue roofers. They can sue pipe fitters. They can sue the fire and sprinkler people. These are likely listed.
Well, I understand that might be a very powerful reason to say that they could do what they've done if they clearly made it applicable to existing contracts, as opposed to policies issued after the law came into effect. But I don't see how that point that you're making has anything to do with what I was talking about or what the chief was talking about.
I think the issue you may be trying to get at is any impairment possibly tolerated. That's, are we, is
no,
that?
I don't think we're
I think maybe I can.
I'll suspend.
Could I just say, this is going to be a very simple kind of question, but I think it's kind of going off of what they're saying is, I'm having, what is your best argument that this is not simply a statute regulating insurance policies? And what can the language of insurance, what can be in an insurance policy and what cannot? Because it seems like your argument is focused on this is regulating subrogation. I don't know that I view this as regulating subrogation. I view this as regulating insurance policies, just period. And we've generally said if the legislature does that, it's anything after that date unless they make an intention to be before that. So that's kind of a very straightforward version, I think, of what they're saying is that why is this just not a general insurance policies shall not have this, they shall have this, and it moves forward?
Because I see this as an immunity at the end of the day, that part is not going to be enforceable for this particular defendant.
In insurance policies, in the language of the insurance policy.
For associations, this is not going to be enforceable against them.
I think if I were to try restating what you're saying, tell me if I mess this up. One way to look at this is the chief is right. This is about regulating the content of an insurance policy. But our job in determining the retroactive effect of things, as we said in Metro-Dade County versus Chase, is the court, quote, the court must ask whether the new statutory provision attaches new legal consequences to events completed before its enactment. A policy is not an event, okay? The retroactive assessment is about happenings. It's about facts on the ground, not the terms of the policy. And here, the relevant event is the loss, is the accrual of the cause of action. Am I understanding this to be your argument?
It is, because until we have that, we don't know if this insurance policy is even obligated in any way to pay for that. And that critical event doesn't happen until after the effective date of the statute. And that's exactly why it's not being retrospectively applied, okay? One of the things that Landgraf said is that just because you're upsetting prior expectations of the law, it doesn't mean that the law is being applied retroactively. And here, what I feel that the Fourth did wrong was it just kind of went ahead and gave it retrospective effect. But in Devon, Chase, all of those cases, it says it's a rule of construction that a statute is not going to be given retrospective effect unless its terms clearly show that such an effect was intended.
Do you think this could vary policy to policy depending on the language? Because the policy here, if I have it right, and I find it interesting that neither court discussed it, but if I understand the policy language correct, it's that it says if we make a payment under this policy and the person to or for whom payment was made has a right to recover damages from another, we shall be subrogated to the right. So that's it's almost a contingent subrogation. If they have the right to recover, we get to recover. So conceivably that right could change over the course of the policy depending on the legislature's policy decisions. If a policy explicitly said we have the right to recover against your condo association in the event of a loss, would that be a different case in your mind, or is this kind of a blanket rule regardless of policy language?
I think it really doesn't matter in a way what the language is exactly. I think it is that associations, they are recalibrating the relationship here. Okay, remember before 2010, they were basically prohibited. Here, they don't go back and say, we're just getting rid of subrogation clauses. They could have done that. They could have even said, we want to do it retroactively. They don't do that. So when they don't say that, we basically stop at the first prong, and we're not supposed to give it retro. We're supposed to be asking, can this thing, there's this presumption towards prospective application. And to me, this gets back to, we have a rule of vestedness here. We have applied it to every single litigant where we have actually looked at the cause of action. We've looked at the nature and quality of the thing taken away, and there shouldn't be a different standard here for insurance companies. I think that one of the things here is something the legislature has done. I do think we need to look at what is within the powers of the legislature here, okay? And they didn't touch upon a vested right, and that is one of the reasons that this thing can be applied after July 1, 2021 without having retrospective. And it is well within their legislative prerogative to create prospective defenses or immunities for third parties, especially where we are dealing with an unaccrued common law tort that may or may not happen. So this court has said causes of action, they're like species of property. But the legislature remains free to create substantive defenses and immunities for use in adjudication. That's Clausel. That's Old Port Cove.
But that doesn't mean that we presume that the legislature intends to write existing contracts. That's a different. I mean, and again, this is why it's so complicated. But I go back to what the chief and I said earlier. We've got this thing about contracts. There's something, that's a special thing. And whether your right to damages may have your right to a particular performance or something like that has actually matured under the contract, but you still got a contract. And the legislature typically, we understand that the legislature doesn't go messing with contracts unless they're very clear about it.
Exactly.
Because we do kind of think contracts are not absolutely sacrosanct, but they are something that should be protected.
Yes.
Or certainly from inadvertent interference by the legislature.
Yes, and our point is they're really not messing with the contract in a sense. They are basically saying
Well, I
for
think
this
your opposing counsel there would disagree.
In the face, and I'm sorry, in the face of the statute, I mean, that's the thing. The legislature had many different ways to skin this cat. They could have written in terms of immunity, so-and-so has immunity from this point forward. From this point forward, so-and-so can't sue so-and-so, whatever. They did not choose to do that. They chose to write a law that expressly says this is what can and cannot be in a contract. So before you even get into the power analysis, the first threshold question is, what did the legislature do in this law? Before we start asking, did they have the authority to do what they did? And at the step of asking what did they do, they chose to regulate contracts. When the legislature does that, we have our standard test for, okay, well, did you intend, quote unquote, to be regulating existing contracts? Yes or no? Seems like the obvious answer here, if you believe that that's the right way of looking at it, is no. Case closed. Why is that wrong?
Because in the future, laws are meant to be future written, okay? They are basically telling them, do not write your policies this way. This is one association that will have a defense if they have given up this right. And here I'm sorry.
Go ahead. No, go ahead.
Okay, the critical event, okay, we are talking about is you have to have an event of loss before subrogation as a concept can accrue. That doesn't happen until after the statute goes into effect. This is exactly why the Second District Court of Appeals said.
Okay, Justice Cordell has a question.
I'm sorry, I don't want to eat into your time. What if we went to coverage instead of subrogation? What if, let's say the policy is against earthquake loss, and the Florida and it's for $1 million worth of coverage, and I've been paying premiums. Let's say I've paid $100,000 worth of premiums, okay? And the Florida legislature passes a law that says no payout in an earthquake shall ever exceed $500,000. Cannot that at that point I haven't suffered a loss, okay? Legislature passes the law, I suffer a loss, and now my coverage is restricted or not?
So in that example, yes, there's a substantive right, and that's exactly what the second DCA said, that if you're looking at a policy contract, we're looking about between the rights of the insured and the insurer. Now you're getting into the contract as it
coverage is different because it's vested.
But in his hypothetical, the law says you can't pay out $500,000. What if the law said an insurance policy cannot include coverage for an earthquake that's over $500,000? Would you assume that applies to existing policies? That's the comparison here.
So yes, but in that case, you're affecting the rights as between these two parties to the contract. Here, this is someone who is well outside this contract that is enjoying a legislative created immunity.
Okay, we're going around and around on this. So you can have 30 seconds to finish up, and then you can have 2 minutes for rebuttal.
Okay. The way I see it from the way the Fourth set it up is an insurance contract, which is only between an insured and insurer, so sacrosanct that the Florida legislature is handcuffed from creating a reasonable immunity for an often abused third party to utilize to defend against subrogation suits that may or may not arise. Okay, we're talking about a third party who's not a party to this contract. Can they accept the benefits of what is an immunity statute? And the law protects vested rights, not theoretical possibilities. The law from SCOTUS to this court has been that a law is not retrospectively applied just because it changed prior expectations of the law. That tenet should not change just because it's an insurance company. Thank you.
Thanks.
Good morning, Your Honors. May it please the Court, Nancy Stamper for Universal. I'd like to start with the Pearsall case. I wasn't going to do this, but I think the Pearsall case lays the groundwork for where we are today. Pearsall has 3 different varieties. It says first, there is a vested fixed right of future enjoyment. As far as Universal is concerned, its vested right of future enjoyment is if there's ever a time where we are obligated to pay you, Ms. Senko, insurance funds, then we have the right to subrogate. That's a vested right of future enjoyment.
That's not exactly what the insurance contract says. It's not a if then, it's if you have the right to recover, then we shall be subrogated to that
Correct.
right. So why, I mean, that language is still intact and can be applied without affecting the policy language at all. Only the nature of the right, which is extra contractual, has changed. So why is that a impairment of the contract?
Because she still has the right. She can still sue Grove Isle. She didn't lose her right. Only the insurance company lost its right.
No, that's what I'm saying. The insurance company still has the right of subrogation. So in other words, nothing about the contract has been, you could have this contract the day before and after the statute can be applied, under the language of the contract the exact same way, but now the nature of the right has changed. It doesn't say explicitly, we retain the right to sue your condo association. It's just if you have the right, then we get to exercise the right of subrogation. So why can't that be applied from a contractual standpoint the same before and after?
It is Universal's contractual right with Ms. Senko. There doesn't seem to be any case, I don't think either one of us found one that is in this context, which I think is why we're here today, because of the subrogation. But the right we bought was the right to sue. And we did that by adjusting
right
the
to sue
policy.
if there's the right to sue.
If there's a right to sue.
Without any sort of limitation on.
And there is still a right to sue.
A date of when, a date of a right to recover and that sort of thing.
The right to recover still exists, but not for Universal. And that's why our position is this affected the contract, the policy, and not the right to litigate. And I think if you go back to the Pearsall case, there were 2 other, RAM keeps coming up, RAM, Justice Kennedy, your case.
I've heard of that.
That's not this context. That
was an illegal contract.
That was an illegal contract. This is a legal contract. That is Pearsall's second category. Expectant depends on continued existence of present condition. That's a changed statute. I had a right under a statute, statute's gone. I have no further right, and I can't reach back to the statute because that was a matter of legislative grace. A contract is not a matter of legislative grace unless it's an illegal contract, and this is not an illegal contract. And the third category was contingent rights. They're contingent upon the existence of another event. Well, that's like the Raphael case. The third category that we deal with in these retroactive situations is tort law. Tort law, I have to vest my right. That's Raphael. The jury said, yes, you get your money. Then the legislature changed, and this court said, you don't change that vested right. That's a vested right. What we're talking about here.
Well, I mean, it's actually, the right's vested when the cause of action accrues in that context.
More accrued than right.
You don't have to necessarily get a judgment. It's even more vested once you got a judgment, for sure. If you can think in terms of more vested, but it's. I think our law is that once a cause of action in that context, we're not talking about contracts, we're talking about the tort context. Once a cause of action accrues, then the legislature is restricted in what it can do to unsettle the rights that are associated with the already accrued cause of action.
And
correct?
That's the Raphael case, right?
Can
yes.
I,
I think I personally think that the second DCA and Laguna got confused on what we bought with our policy. We bought a right. The right exists. The right still exists. We traded
what you bargained for,
premium.
because you didn't pay anything, but
We traded a premium. You know, you get
Right.
these premiums are set based on what you get and what I get.
So that's my question.
I'm sorry, Judge.
That was my question. Is this thing working? That was my question.
It's these, not that.
To you, Universal. I mean, they were able to charge the policyholder the cheaper premiums because they believed they could subrogate later. Correct?
Correct.
So that's the right that I think we're talking about.
That is
there was
the
a
right.
bargain between the people who own condos. They would get this policy cheaper, but yet in the what they are able to subrogate later on from the wrongdoer.
Correct.
And that's basically going back to what Justice Kennedy mentioned earlier, the legislature messing with existing contracts. I mean, Universal would not have offered that policy if had they known that later on they were not going to be able to
They know
collect.
better now, Judge. Policies changed. But you see, if the legislature had said, we're going to eliminate subrogation, we're going to eliminate no more subrogation. But an AOB is a subrogation contract. That the subrogation still exists. It's a contract right. Had they eliminated the tort, I guess the tort would have been Ms. Senko's right to sue the association for the water damage. That would have been the tort that the legislature could have eliminated, because they can do anything they want with tort law. But they didn't eliminate the tort. They didn't even eliminate the subrogation. They eliminated Universal's policy right, which it purchased. And I don't think...
But your position is they actually didn't. They didn't do that because
they can't.
It's not intended to affect existing policies. They do it, they affect the policies you're going to issue in the future, but not...
Prospectively, fine. Retrospectively,
right.
Not under any case from this court.
But do you agree that this statute on its face only applies going forward? Or do you think because of the July 1st, 2010 and subsection 1 that is the effective date throughout each subsection?
It only applies going forward for two reasons. Number one, the intent of the statute on its face doesn't express any intention to retroactively apply it. But number two, we've combed the bills, we've all combed the bills, the legislative stuff. There's nothing that says the legislature intended this to apply retroactively. And that's the first of the two tests, the two-pronged test. Did the legislature intend? And the answer is no, and Grovile admitted that.
Don't to accept that argument, though, we have to have this July 1st, 2010 date confined to subsection 1.
I'm sorry, Judge?
Don't we need to accept that argument? Don't we need to say that the July 1st, 2010 date is confined to subsection 1? Or do you think it can go 2, 3, 4? Because
July 21st was the date of, I think, July 21st was the date.
Yes, I'm just talking about the language of the amended statute. So sub A says for policies issued or renewed on or after July 1st, 2010. And then it goes on to say that, it has to have this coverage unit, the maximum amount of any owner's unit loss assessment coverage, regardless of the number assessment. So in other words, it all seems to be requirements relating back to sub A with that
to
date.
The day that right.
So I think the issue is, do you think that the statute on its face can be interpreted in a way that says the legislature only meant to apply this, we don't even need to get into a retroactivity analysis? Or do you think that your argument depends on the kind of substantive right retroactivity analysis?
No, I think the legislative intent is clear on the date that this amendment was effective. Just as you said, it was effective as of, I thought it was July 21st, but maybe it was July 1st. But it can't relate backwards to my April 30th policy. It must relate forward.
I'm just asking whether the date in subsection 1 extends to 2, 3, and 4.
No, the date in subsection 1 has nothing to do. This subsection 4 has its own enacting legislation, and subsection 4 clearly says that and I think the fourth DCA addressed that also. In fact, I think the second DCA said we're not applying a retroactivity analysis because it doesn't work. Those courts agreed that you can't retroactively affect this contract. The fourth said, and that's the end of the day. The second said, no, we can move on and do something else. We can address the subrogation right. And I think where they got it wrong is, and I think Judge Arto did also, they focused on cases like Villa Maria that talk about the cause of action, and when the cause of action is perfected. That has nothing to do with what we're talking about here. We're talking about a prospective right. Universal may never have the right to subrogate, may never have, but it bought the right if they ever want to do it. You know what that's like? I may never bear arms, but I have the right to bear arms. And nothing can take that right away from me. That is a right I have now for a prospective enjoyment I may never use. The right to worship, the right to peaceably assemble. Those are prospective rights based on...
It's like the right of a policyholder under an insurance policy. You hope you're never going to have to make a claim.
You pray.
Okay, you pray you don't have to make a claim, because therein lies difficulty frequently. But the right to make a claim and make a recovery for a covered loss is a very important contractual right, even though it hasn't accrued yet. But under that policy, that's what you've been paying those premiums for against the day that you might need it. And then they come along and say, oh well, that policy we're going to do it because it hadn't accrued. We're going to be able to cut that off. That's a different, absent some really good reason. That's just not the way these things work. I know I'm just preaching to the choir here, but when you look at this language here,
I'm glad you are, Judge.
This language that the legislature passed says that in these certain circumstances related to the condominiums policy, an insurance policy issued to an individual owner in the association may not provide rights of subrogation. It's talking about a limitation on the provisions of a policy. Now, how could they be talking about limitations on the provisions of a policy when the policies have already issued, as opposed to policies that are going to issue in the future after the effective date? Now, again, that's your argument, I know, but it just seems to jump out when we actually focus on this language here.
The legislature has retroactively rewritten our policy.
No, they haven't. That's his point.
But is that they didn't. If we were to accept opposing counsel's argument, it would result in that.
It seems like you're trying. I mean, I think you should win, okay? But you're making your case more complicated than the fourth DCA made it, and that it needs to be. I think what he's saying is that if you just read the statute in the most natural way, it doesn't even apply to this contract. So you don't even need to worry about which box to put the kind of right into and when it accrues and whatever. You only get into that whole complicated mess when you start with the premise that the legislature intended to take away whatever that thing was, and then you have to argue about how to categorize it and whatever. But if the legislature didn't disturb it in the first place, if the law does not govern this contract, then we don't, which is what the fourth DCA, that's what the majority's reasoning was. So it seems like that's the easiest claim.
I agree. I did not mean to overcomplicate it. Our first position is there is no legislative intent, and that is what we argued to the 4th District, and that's what we were successful with in the 4th and lost in the 2nd. And I think this is a pure contract construction retroactivity case, and this court has spoken on it at least a dozen times that I know of. So if Justice said, and I'm sorry, Justice, I have hearing aids, but they don't work all that well.
That's fine. I might have said A instead of 1, too. It's fine.
Thank you. I respectfully request that you affirm the 4th DCA's and reverse the 2nd DCA's opinions. Thank you.
Thank you.
The cause of action actually existing because there is no right of subrogation without underlying loss. Until then, it is theoretical, it is contingent, it is inchoate. The Florida legislature has the right to prospectively change immunities, defenses, things going forward on a prospective basis.
But that's not what they did. They changed the policy. They're saying, they're talking about, if what I read here, they're talking about what can be in a policy, that the policy may not provide rights of subrogation. It's directed at policy language.
Yes, I do understand that is the text, but in terms of here, this law, in a sense, it is future-looking, that it is telling between unit owners and association master policies, this is how it's going to play out. But here, it is being prospectively applied because it's not attacking subrogation rights that were in a prior policy. Okay, it just isn't. It's not changing any of it. It is still saying, okay, it's there, but are we applying this prospectively? And we can't do that without having a fully mature, ripened cause of action.
Well, but your position requires, basically your position says that because of this legislation, in this existing policy, you got to line out that you got the part there, you've got the two different provisions. You got to line out the provision having to do with subrogation. And I don't see any other way you read what the legislature, the way you understand what the legislature has done. Now, I think that's not the way we typically would view that.
I understand what you're reading, but it only applies to associations. The subrogation contract is still whole in there, and there are so many other categories of people that they can go after to recoup 10, 20 cents. But the legislature here is prospectively.
Well, so you wouldn't be lining it out except for claims against the condo association. You'd actually be adding words into it as opposed to lining it out.
One of our former colleagues would have called it something like a Faber College codicil. Okay, you can have 30 seconds to finish up.
Okay. In order for Universal to overcome this presumption of prospective, I just want you to see what it has had to do. Okay, it's had to ask this court to ignore longstanding Florida case law requiring an examination as to whether we're speaking of a vested right. It has had to bootstrap its subrogated cause of action starting after the statutory date back to its antecedent policy date, and then it has had to foist its substantive rights as the second DCA, which exists only as it's bargained for between itself and its insured onto third parties outside of the contract. We would ask this court to follow all of the case law, and we understand that this is a dicey area. We're just going to say that, but we expect you to follow the same case law that you have had all along and apply it here. And in this case, we would ask that this court would approve the Laguna Rivera decision and quash the 4th District.
Thank you very much. We're adjourned.
All rise.